Okay, so last time, if my understanding is not incorrect, you guys have covered cross-examinations and direct examinations, and that's kind of the meat of what a mock trial is. That's going to be around 80 to 90% of the time of itself. But objections are what I personally find to be quite fun. And so you might have heard about some rules of evidence that govern a mock trial match. And so that's essentially saying what kind of evidence you can offer and what kind of evidence you can't offer. For instance, we don't want rampant speculation in a courtroom. We don't want hearsay in the courtroom. So there's stuff that you can say, there's stuff that you can't say. And if you think the opposing side is breaking the rules, that's when you use an objection. And so objections are based off the rules of evidence. In this case, we use the American Mock Trial Association's rules of evidence, which are based off the American Federal Rules of Evidence, as we are doing American style mock trial. And so we're going to go over a couple of main objections here and also how to format an objection, which I'll be demonstrating later with Jesse. Here I've listed four main objections since in most cases you're not going to see character as often, but in this particular case, as it is a lot about racism, there is a strong element of character in it, and so we're also going to be going into character more in depth there. There's one particular format which we use for objections, which is called the IRAC format. And so actually just for some context about when you make an objection, you tend to make an objection just objections are made by shouting out. You in a Zoom room presumably unmute yourself and you just shout out objection with the express purpose of interrupting the opposing counsel or opposing witness. Or and so I don't know, the direct examination of your opposing team might be happening, or the cross-examination of your witness might be happening. You just shout out objection. So from there, what do? That follows the IRAC acronym. So it's issue, rule, application, and conclusion. Typically speaking, in your initial objection, you're just going to do issue. So objection, Your Honor, on the grounds of hearsay, or objection, Your Honor, on the grounds of speculation. And so and then you wait for the judge. So objection, Your Honor, on the grounds of speculation, Your Honor, may I be heard. And then if the judge lets you talk, you can talk at that point. And you can go through the rest of the RAC, of rule, application, conclusion. And once again, I'll be discussing a little bit more of the of what exactly this means in the context of specific objections. And I'll get back to responding to objections in a little bit. So let me use a pretty simple objection to explain objections overall. So speculation is a objection that says that witnesses aren't allowed to testify to things that they don't really have personal knowledge of, that because we don't want someone who doesn't really have a good understanding of something to just speculate. So one really obvious instance of this is medical condition. So if someone is unhappy, you don't really know that they're unhappy unless they demonstrate it obviously. If someone is walking around with a poker face, maybe they're happy, maybe they're unhappy, maybe they're sad. The fact of the matter is that you don't really know. And so if a witness gets up onto the stand and testifies that they were sad or they were unhappy, there's no real basis to this. And so that shouldn't be allowed because you don't want testimony that's not based in reality, not based in facts to make it into the courtroom. So speculation is governed by a rule that's in the American Mock Trial Rules of Evidence called Rule 701, which essentially says that opinions made by lay witnesses must have a rational basis to it. If you say that someone is sad, you need to explain why you think they're sad. They were sad because they were crying. They were sad because they were frowning. They were sad because they were saying they were sad, perhaps. So going back to the IRAC format, how would you make an objection on speculation in that case? Objection, Your Honor, speculation, that's issue, and may I be heard? Or you can honestly just wait, and the judge will probably ask you to explain anyways. Objection, Your Honor, speculation. Under Rule 701, the opinions of lay witness testimony must be based in a rational perception. However, in this case, the witness is testifying that a particular person was sad without explaining why they were sad, without giving a rational basis, and that's why this is speculation. The foundation needs to be laid. So we went to the rule. What's the rule? It's 701. What's the application? Why is this rule applicable? And why then is this like just a general conclusion? It's not that complicated. This is speculation. And so that's kind of the full formal way of making an objection especially if you're going for something more complicated, especially if it's something like character or more prejudicial and probative when you are having these multiple components. But for a simple rule like speculation, you can usually just go objection, Your Honor, speculation. The witness is speculating towards the mental condition of someone else without explaining a rational basis. That's speculation. And so you don't always actually have to have the rule number, but in general, it's good form to have rule numbers just because it clearly defines the objection and it overall lends credit later on to share to you. And so you guys can go over this more clearly. There's also great resources like Winning Objections, the book, and the actual rules of evidence themselves are also great to read as well. But in consideration of some lack of time, I'm just going to go through these relatively more quickly. So lack of foundation. What's lack of foundation? In general, lack of foundation is kind of this idea that they haven't established enough um, evidence to say something. And the lack of evidence in general is not necessarily objectionable. There's a few specific contexts that you want to use it in. The first context is that someone comes to a conclusion without sufficient backing. And so we're going to go over something similar to this in improper opinion, but Rule 702 is the rule that governs experts' opinions. And so these are witnesses with a special qualification to testify, like a psychologist would have a special qualification to testify about psychological issues. And so the idea of an expert opinion is that they don't necessarily need to have the obvious rational basis that a lay witness opinion does have. You can use more obscure methods to come to your conclusion, like some kind of deeper psychological analysis, but that they still need to have some kind of backing behind them. And that's laid out in Rule 702 ABCD, that you need training, data, methods, reliable application of your methods to that data. Maybe not necessarily in that order, but if we consider that you have to lay this foundation, kind of the backing behind making a conclusion, you need to lay the foundation of A, B, C, D. And if you haven't laid all the foundation of A, B, C, D, we'll consider that to be a lack of foundation, and it's objectionable under lack of foundation. So once again, applying the IRAC method, you might say something like, objection, Your Honor, a lack of foundation. Rule 702 A states that an expert must be qualified in some kind of specialized knowledge, but they haven't given us the foundation, they haven't given us the evidence that this expert has special qualifications. Thus, this is lack of foundation, Your Honor. There are also some other instances in which lack of foundation might be laid. For instance, when you're entering evidence under Rule 901, you need to do authentication. And essentially, you just need to ask the witness if this is what it purports to be, what it claims to be. And that's usually done by just asking, as you should have learned last lesson, the procedure of entering evidence. Is this a fair and accurate? What is this? Is this a fair and accurate copy? Has it been altered in any kind of way? But if we don't believe that the opposing counsel has laid sufficient foundation, that this is an authentic exhibit, that is what it purports to be, then you say lack of foundation, Your Honor. under Rule 901, in order to enter exhibits, you need to sufficiently authenticate it that it purports to be what it is. In this case, they haven't laid the foundation that this hasn't been altered in any way, or that it's a fair and accurate copy. And in that case, Your Honor, it's lack of foundation. In general, lack of foundation is a pretty broad objection. It can be used in a lot of different scenarios. And you're basically just saying, I'm not saying that opposing counsel is incorrect, but I am saying that they haven't shown us that they're correct. Right? I'm not saying that opposing witness is not correct, but they haven't shown us enough for us to know that they're correct. And so it's basically asking them to go back and just be a little bit more thorough in their methodology, be a little bit more thorough in how exactly they're approaching the claims they're making in court. And so for the team being objected to themselves, this oftentimes isn't necessarily that bad either. Just because even if there is a lack of foundation, a lot of times you can recover by simply going back and laying a foundation, by asking the witness if it's a fair and accurate exhibit, or by discussing the witnesses, by asking the witness about their specialized qualifications to testify towards expert opinions. And I'll just go into an example of lack of foundation. Um, this kind of also goes, so this is actually a different usage of lack of foundation to what I previously discussed. And so in this case, this goes towards kind of an attorney assuming facts, not evidence. For instance, in this case, the defense attorney asked right away, why does the witness refuse to design capes to go along with the superhero outfits they create? And so attorneys are not really allowed to discuss evidence. They're not allowed to make claims in court. And so when they do say something that hasn't been established already, such as Edna designing capes or Edna creating superhero outfits, we can consider that to be a lack of foundation, that we don't necessarily consider the attorney to be incorrect per se, but that we believe that they haven't shown us enough that they're correct, that they need to go back and ask the witness what the witness does and kind of lay the claims that they're making in their questioning. So in this case, once again, it's not that difficult to recover from this type of objection. As I said earlier, you can just go back and lay the foundation. In this case, the attorney just goes back and asks the witness, what do you do for a living? And such. Improper opinion is quite similar to the earlier discussed lack of foundation. It's kind of a lack of foundation is oftentimes used for improper opinion. I personally like to use improper opinion just because it's a bit more specific. But improper opinion is kind of the argument that an opinion is made without, generally speaking, an expert opinion is made without the sufficient backing. And so I mentioned earlier that you need to establish 702 ABCD to make an expert opinion. And so if that hasn't been done sufficiently, that's an improper opinion. For instance, a psychologist probably shouldn't be testifying about things like about computer science or unrelated fields. That's a violation of 702A. Or maybe they haven't laid enough foundation. That's also an acceptable time to make an improper opinion argument, or really anything that relates to just that opinion not following the rules of evidence. So this is kind of similar to this type of objection being made in this example. It's pretty similar to a lack of foundation objection. And really what's happening here is that the prosecution has established this witness as an expert in the field of memory, but they haven't established the facts and data, the methods, or the reliable application of those methods. And so defense counsel is arguing that a conclusion at this point in time, without the facts and data, without the methods, and without verification that these methods were reliably applied, is improper opinion, and that the foundation hasn't been sufficiently laid. And so in this case, the attorney does get their objection sustained, but once again, it's really easy to recover from this type of objection. You just go back and you ask the witness, what facts and data did you review? what um what methods did you apply? Maybe did you apply those methods in this context, or were there any issues with the way you applied the method or such and such in order to lay sufficient foundation for 702 BCD? Finally, yes, one objection that I actually recommend that you, generally speaking, don't make is on relevance. It can be done on when you're on cross-examination, but relevance is just an objection that something doesn't matter to the case, and something would be considered relevant if it just contributes to any fact of the case, any material fact of the case being more or less likely. So, for instance, what is a relevant fact? A relevant fact might be whether your witness is biased or not. Credibility is always relevant, right? Because it kind of influences the way the jury interprets the witness's testimony. And so even if you might be tempted to object relevance to a question about, whether your witness might be empathetic towards certain races or certain genders or such and such, it's actually relevant. And because even if it might not be directly related to the case, it can make facts of the case more or less likely. So actually, in general, you have the idea that if the opposing team is talking about something that's not relevant, maybe it's good for you. It's resulting in a lack of focus for their case. And so there's very few scenarios where a relevance objection is made. Potentially a relevance objection can be made on like cross-examination if the opposing team is trying to attack your witness in a way that doesn't necessarily affect the case, like asking about something like their personal history on cross-examination to make them out to be a bad person when it doesn't necessarily affect the way that they testify in this case. But in general, relevance objections, it's not that they're rare, but it's that they're rarely well done. And so I personally don't strongly recommend using these. The leading question is just on direct examination. You can't ask leading questions. And I believe this was also covered in the last lesson, but that on direct examination, you can't ask questions that suggest an answer. Weren't you on a track and field team? That's a question that suggests that the witness was on a track and field team. It's just really asking for a confirmation. Yes or no questions are allowed though. I think it's a common mistake that people often make that is mistaking a yes or no question for a leading question. Were you on the track and field team? That's not a leading question because it doesn't really suggest an answer. And there's a couple more objections like counsel testifying, assuming facts, not evidence, et cetera, that have not been covered in this PPT, generally speaking, because they're not as seen, or because there's overlap with existing objections that we've covered. But in just one moment, Jesse will be covering hearsay, and then I'll go back and talk about character. One thing that I do want to highlight is badgering the witness. In general, we consider that attorneys should avoid interrupting the witness. How much that's okay is up to judge interpretation. I personally subscribe to the idea that an attorney should never interrupt a witness, just because a lot of judges also subscribe to that. Whether or not in a real courtroom, interruption of witness is okay is something I'm not going to get into. But in mock trial, a lot of judges subscribe to the idea that you should not interrupt a witness, which is why which is why I also subscribe to the idea that you should never interrupt a witness. So badgering witness is generally made on on your opposing team's cross-examination. And that's when they're kind of attacking your witness or kind of cutting your witness off a little bit too much, just making your witness not really welcomed in this courtroom. So something that's badgering the witness can be, you know, personal attack, like I think your voice sounds terrible is obviously badgering the witness. It's also likely counsel testifying, or lack of foundation, but it is also likely badgering the witness. Cutting the witness off should be dealt with badgering the witness objections. Oh, lastly, how do you respond to an objection? You just explain why the other side is wrong about kind of the evidentiary backing. For instance, if there is a rational basis to something that the opposing team objects speculation to, then you just say, Your Honor, a witness has established a rational basis under 701. They said earlier that this person was crying, and so it's rational to conclude that this person is sad. Okay. At this point in time, I will give me one short moment to open up a different set of materials, and I will be handing it off to Jesse to talk about hearsay. Whenever you're ready, Jesse.
Okay, sure. So, hello everyone. Today I'm going to talk about the first important objection, which is called hearsay. So, before we come into any depth, let's talk about the definition about hearsay. And it is according to Rule 801. And so, as we can see on the screen, 801C, hearsay means a statement that the declarant does not make while testifying at the current trial, and a party offers an evidence to prove the truth of the matter asserted in the statement. So we have a few definitions that we should talk about. So first, what is a statement? A statement means a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as a assertion. And so declarant means the person who made the statement. So basically, hearsay is a out of court statement made for the truth of the matter asserted. And so on the next slide, we are going to talk about a few examples of hearsay. So as shown on the screen, there are two examples. For example, an eyewitness says, I saw a green car to the police officer. And the opposing counsel tries to enter text message from the victim saying how much the defendant hated him. So in both of these examples, we can see there is a statement which qualifies 801A and a declarant which qualifies 801B, and it is used for the truth of the matter asserted according to 801D. So evidence like these are considered as hearsay. So after looking at what are hearsay, we're going to talk about what is not hearsay. And today we're going to talk about basically three cases hearsay. And first is 801D. However, we do not much care about 801D2, 801D1, and we usually focus on 801D2, and we often use it in court. So basically, 801D2 means it is not hearsay if the defendant said something and the prosecution is using it. So this is the first case that is not hearsay. And so on the next page, this second case, which is not hearsay, is actually called non-truth purpose. So just now we talked about one criteria of hearsay should be the evidence to prove the truth of the matter asserted in the statement. However, if some evidence is not used for the truth of the matter asserted, it is not considered as hearsay. For example, the witness says blah, 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 and I later found out it you're obviously not trying to use that blah, blah, blah to testify the truth of the matter. You're obviously not trying to say that a lie is the truth, and thus not hearsay. And another example is that he told me that he needed help, so I drove to the scene of the crime. This is not to prove the truth of the matter asserted, so this is also not hearsay. And now we will move on to the third case of what is not hearsay. And the third circumstance is about statement. So just now we talked about how a hearsay must be a statement and assertion. However, if a piece of evidence is not an assertion, it is not a hearsay. For example, how was your day? Can you pick up the clothes? These are not assertions. They are just questions, so they are not hearsay. And after talking about what is not hearsay, we're going to move on to some exceptions of hearsay. So, exceptions means that something is indeed hearsay, but it is okay to use in court. And there are actually 23 exceptions to hearsay that we care about in mock trial, but we do not need to use them all. And particularly we need to focus on these exceptions to hearsay. And the first one is Rule 8031, which is the present sense impression, a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. 8032, it is a statement relating to a startling activity or condition made while the declarant was under the stress of excitement that caused it. And also 8033, the then existing mental, emotional, or physical condition. And also 8036, records of a regularly conducted activity. And also potentially in some specific cases, we may also use 80321, which is the reputation considered character. And this specific case, we would advise you to also pay close attention to 8035, that is the recorded recollection, and also 8038, which is public records. And now after talking about the basic about hearsay, we're going to demonstrate some examples of hearsay. And because we do not have a judge here, Corey and I are just going to do some objection response. However, in a real court, please ask to speak for permission before you speak and also hear the judge out. Um, so the first example that we have here on screen is an exhibit evidence, Exhibit 4, Betty Darrell's relevant search history. So an objection to this example is that this is hearsay because relevant search history is information out of court. So are there any responses?
Your Honor, there's no statement being made here under Rule 801A. Hearsay needs a statement to be made, but these are all either questions or phrases. There's no assertion being made here. Thus, doesn't qualify as a statement, doesn't qualify as hearsay, Your Honor.
Yes, so this is actually not hearsay. As we can see here, there is no statement, there is no assertion. So as there is no statement being made, this is not hearsay. So let's see the second example. And so the prosecution witness testifies that defense witness told the victim that I'm going to kill you. So I'm going to kill you is an assertion made out of court, so this is hearsay.
Okay, a side note here, I'm not entirely sure if this is supposed to be defense witness or defendant, but Your Honor, this is an instance of either 801D2 if it's the defendant, opposing party statement, because the defendant is allowed to, because we're allowed to enter evidence of the defendant. That's probably what it is.
Okay, yeah, so this is not hearsay because according to A1D2, the opposing party's statement is also not considered as hearsay. So this is the
Just
part about,
okay, so this is supposed to say defendant, by the way, because if the defense witness says something, then that is not necessarily that, but if the defendant says something, then prosecution can always use it. That's basically a meeting of 801D2. If it's just a witness or if it's honestly just anyone saying it, I make the argument that it's allowed under 8033 for intent purpose, but in this case, the obvious response is 801D2. Please continue, Jesse. I apologize for the slideshow mistake.
yeah, so this is under A01D2 and it is not hearsay because it is opposing party statement. Okay, so we will move on to character.
Okay, I'll just actually quickly go over a few more examples just for the benefit of the audience, especially since hearsay is a pretty complicated topic. And I'm just gonna pull up a case packet that I've done in the past and I'll go over just some stuff from there. So we just discussed earlier this kind of idea that hearsay has really three main components. That it's an assertion that someone a person said, and that it was an assertion that's being offered to prove something, essentially, to prove something inherent to what's said in the statement itself. And so, generally speaking, in a case packet, all evidence is meant to be utilized in some kind of way in a case packet. And oftentimes, the most common time hearsay shows up is in objections to exhibits. And so, really, the question is oftentimes of whether or not the correct witness is using this or in the correct context. So, I just want to go over some of these exhibits because many of these are written assertions. Many of them are being used to prove the truth of the matter. And once again, I'd just like to say that statements, oral statements are also hearsay. Hearsay is a pretty broad objection. It's used in a lot of contexts. It's basically essentially whenever someone says something out of court, and you kind of want to introduce that into the courtroom to prove something. So this is an example of an exception to hearsay. It's an 8036 recorded record of regularly conducted exception. And so this is obviously hearsay because it is an assertion that this particular person did buy these items, that it was presumably produced by the cashier, and that's why it's an instance of there's a declarant, someone made it. You're presumed to be using this to prove that there really is these purchases being made. And so in this case, the reason why it's allowed to be used is because if a business regularly produces records of an activity, in this case, that they regularly record that the purchases and transactions are being made, then we consider that even though it's hearsay, it's allowed in court. And once again, the rules of evidence themselves have much more specific guidelines on this, but that's just the general vibe that I explained. And you should probably go read the MTRE if you're actually intending on using this. Kind of another note on this is this is kind of similar to the earlier example presented by Jesse on things not being hearsay because they're not necessarily phrases and not necessarily making an assertion. But there's also another exception, not really exception, but there's another response you can use to this. Because Jimmy Tanks is a defendant and you're presumably the prosecution trying to enter this, you can just say that it is an opposing party statement. Because it's a defendant saying these things, and because you're the prosecution, you're basically allowed to use it. And so, just going back over a broad overview, hearsay is when someone says something out of court and you're trying to use that to prove that they're correct. The car is green, I said that out of court, and I want to offer that in evidence to show that the car was green. But once again, there's a lot of different cases where it's okay to use hearsay because people saying things outside of court, even if it's not necessarily always reliable, it definitely can have value. It definitely has cases where it is more reliable than not reliable. And so I'd honestly recommend for you to go over this lesson and recording again, or go over the slideshow. We have a lot of time, so we went over things a bit more quickly, but the slideshow does go quite into depth over what the components of hearsay are, why hearsay is the way it is, kind of based in the writing of the rules itself. And I would also recommend if you're trying to use an exception or if you're anticipating an exception being used to go read the rules of evidence themselves. Because once again, they are the most foundational way to understand what exactly is allowed and not allowed in mock trial. Okay, I'm gonna go over character now. So normally in this series of lessons, we actually don't go over character. And the reason why I'm choosing to go over character today is because I've been made aware that this tournament is doing the Zimmerman case. And the Zimmerman case really is a question, is a case that's really based around this idea of racism, whether racism was involved, whether or not this guy likely caused a murder because of racism. And that's fundamentally very, very related to character. So what's character? Well, character is kind of this overall idea that um, is based around this phrase propensity. A propensity means that if someone has a certain character, they will act in accordance with that character. A particular person has anger management issues, they probably got angry in some certain situation. For instance, if they were taunted, someone with anger management issues probably got angry. And so character is just the idea that if someone has a character trait, they will act in accordance with that character trait. And that idea we call propensity. So a really complicated question then follows. We say that there's a character trait. We say that character has to involve a character trait. What is a character trait? If I'm wearing glasses, um, is that a character trait? Or if we go into something even more specific, um, for instance, is being someone who really likes a particular line of a book a character trait? And so I think that winning objections, once again, going to that book, Winning Objections, which you can probably find on Google, um, they kind of give a little bit of guidance, but it's kind of a nebulous idea of what is character trait, what is not character trait. But a kind of test that they give is ask yourself if it can be easily summarized. So maybe liking a specific line in a book is not necessarily easily summarized. It's not a broad overarching character trait that says a lot about a person. Um, but maybe something like angry is a character trait. Maybe something like irritable is a character trait. Maybe something like in here, violent, disorganized, faithful. These are character traits as well. So once again, I'm going to character because I think character is really, really relevant to this case, especially since it's in the context of racism, being racist. That's a character trait. I think that's pretty clearly a character trait because it is this simple idea that's kind of all encompassing towards a certain person's behavior. Okay, so when is it okay to do character? When is it okay to actually kind of talk about propensity? So we saw earlier the rule against character in general. That's 404A1. But there's the exceptions when character is in all its forms, in all its wonderful usages is allowed. There's 404A2. And there's A, B, and C. So once again, this is really relevant in this case as well. In this case, the defendant can offer evidence of their pertinent trait. So the defendant can characterize themselves, and then prosecution can come and rebut them. So, if I'm the defendant, I can come and tell you I'm a really peaceful guy, best for my community. Um, you know, I do charity work. I'm an amazing guy. Defendant is allowed to say that about themselves. And I can choose to either say it or not say it. But if I do say I'm an amazing guy, like I'm a really nice guy, I'm a really kind guy. Prosecution, they can come and say, actually, here's all this evidence of why he's not a kind guy. And so just this is called door opening. Defense can offer character of themselves in every situation. But if they choose to offer that character, prosecution, they can come in too and they can say, actually, defense is wrong. Um, and it's called door opening because like you open the door and defense to walk in and start talking about character, and prosecution can follow you too and start talking about character themselves. Defendant can also talk about the victim. And so this is really, really relevant in this particular case because Trayvon Martin has consumed substances like marijuana. That's one of the pertinent facts of this case. So, you can characterize Trayvon Martin as maybe someone with a substance addiction. Um, and defense is allowed to do that. Of course, once defense characterizes the victim, a prosecution can go and rebut that. So maybe he is an addict, but he's maybe he does consume substances. Defense believes that victim is an addict, but prosecution believes that he's not an addict. Um, and so also, this is not as relevant to this case, but um, if you say the victim is an addict, you can also say that if the defense says the victim is an addict, the prosecution can go and say the defendant is an addict. Or if the defense goes and says that the victim is violent, prosecution can go and say that the defendant is violent. Finally, a third really important kind of piece of evidence here is that the prosecution is always allowed to discuss whether or not, okay, not always allowed. In this case, since it is a homicide case, the prosecution can say that the victim was peaceful because this is a homicide case. And there's the argument of self-defense in homicide cases, which is also the argument that defense needs to pursue according to the stipulations in the Zimmerman case, that um the victim started it and that it was a reasonable response by the defendant to kill this person. And so the prosecution is allowed to say that the victim was so peaceful that they couldn't have possibly started the conflict. And it's just a summary of everything I just said. Okay, you're also allowed to use very specific purpose of character. Very specifically, you're allowed to use past acts. Previously, we were discussing character by reputation or opinion, but you're allowed to use past acts of people to prove very specific things. And these are explicitly considered non-character purpose. So if I walk in and I say that because Zimmerman did certain specific racist acts in the past that shows he has a motive to act against racist people, that's okay under 404(b)(2). And in some sense, it kind of is character, because it has some kind of intention in the past. Doesn't necessarily mean that they have that intention in the future, but we're still allowing it in because it's of interest to the courtroom. Okay, so as before, we're going to go through, we're going to do some contemplative objections, and then me and Jesse will be doing that. So in this case, objection on the grounds of improper character. The prosecution is arguing that because the defendant has said anti-Semitic things in the past, they must have acted in an anti-Semitic way in murdering this Jewish person. That's a character trait being used for a propensity purpose. That's improper character. A response?
So responding to that, this is permitted under the rule 404(b)(2) because the prosecution want to use this piece of evidence as motive to prove that they have the motive to murder a Jewish person, and should not be considered under character trait.
Yeah, so this is, as Jesse was explaining, a allowed usage of 404(b)(2) usage for motive. And so this is a specific thing that this person said. This is a specific act being used to prove that they have a motive to kill Jewish people. And that's once again in line with Zimmerman being racist and what I was talking about earlier. Okay, second example. Objection, Your Honor. On the grounds of improper character, defense counsel is trying to use this victim's alleged anger management issues to argue that because they had those anger management issues, they must have started this fight. That's character trait and propensity. That's improper character, Your Honor.
So this is permitted under the rule 404A to B because a defendant may offer evidence of an aligned victim's pertinent trait.
Yeah, so this is a pretty simple kind of objection as well to respond to because defense is always allowed to offer character of the victim. Just keep in mind though that if the defense offers character of the victim, the prosecution is allowed to say that the defendant has the same trait, that the defendant has anger management issues, or that the victim doesn't have anger management issues. The victim is perhaps a particularly peaceful person. Um, Objection, Your Honor. Opposing counsel is claiming that because George Zimmerman has a gun, as a character trait, he possesses a gun. He will therefore use it in the future, and that's a propensity trait. That's usage for propensity, Your Honor, and that's an improper character.
So responding to that objection, there is no character trait as the prosecution just entered evidence that Zimmerman has a gun. That is basically a fact instead of a character trait. So there is not a very strong propensity purpose.
Right. So as Jesse was saying that Zimmerman owns a gun doesn't really mean anything about who George Zimmerman is. It's just a fact. So it's not really a character trait being used here. And lastly, um, so objection, Your Honor. This is an improper character, usage of improper character evidence. They're saying that because this person is an arsonist, that they must be discussing arson. That's character trait full propensity. And
So
I'm not gonna ask Jesse to respond to that because this is a valid objection. How would you respond to this? You'd probably make the argument that this is a character, not a character trait. That being an arsonist doesn't necessarily say something all-encompassing about this person. I mean, in that case, I would consider the relevancy of why you're talking about this person being an arsonist. But in this particular case, we can identify that the character trait of this particular friend of the defendant is an arsonist, that they're trying to argue that because this guy's talking with an arsonist, because this is an arsonist talking, they probably talked about arson at some point. That's a propensity. And there are no identifiable objections to this because there just kind of are no identifiable exceptions. Okay, do you have any questions from the audience at this point in time? If there are no questions, I will take a short break and then talk about statements. Kind of the point in time in which we declare things. We begin by declaring what you're going to see in a trial. We declare that in the trial, you'll see that maybe that the defendant is racist, and so they probably killed this person. And I do believe these are 5 minutes long. I could be wrong about this one, so you should check. But I do believe that you guys are allotted 5 minutes for these. Um, and so you kind of need to explain a case. This is the first time anyone hears anything about um, this case, right? A judge oftentimes hasn't read your case packet. So kind of explain what's going on. And there's two people walking down the street. Then this person pulls out a gun and shoots him. Why? Because this person, as you'll see in this case, was racist. This person had a history in calling so and so. This person had a history of so on and so forth. Right? You need to tell a story in an opening statement, and that's really what you're doing. You're telling a story, and you're telling a story that the jury is going to hear throughout this trial, and they'll emphasize with your story, they'll understand your story, and because your story is true, find the defendant innocent or guilty. But that's kind of unorganized, the way I just explained it. So we consider that there's a structure to it. And actually I will go ahead and pull up one of my older statements to kind of illustrate the structure a bit. Never mind, I don't think I can. Let me pull it up on a different. One moment for mild technical difficulties owing to me being in China. Okay, this is a opening statement. And actually, let me just deliver this opening statement, hopefully of some decent quality, because I haven't seen this one in a while. But I will deliver this opening statement in order to kind of give you an idea of what that might look like. And I do believe that I will have to scroll in the middle, which is unideal, but I will just do it. Okay, so about an opening statement, please stand up. Attorneys should always stand up when they talk. That's just kind of how it works, because you're standing in actual quorum. It allows you more flexibility in movement and flexibility in expression. But let me just get right into it. May it please the court. It was debt-driven desperation. Members of the jury, what is this case about? It's simple. This is a case about a man whose aunt died. And then a man who couldn't cope with that loss. And then a man who fell into an addiction of gambling. And that addiction, it came at a cost. It came at a cost he couldn't pay back. Debt. He gambled and he gambled and he gambled and he gambled his fortunes away and then some. That debt led to desperation. That debt led him to do the only thing he could. That debt led him to burn his own house down. Burning his own house down for the $1 million insurance policy on top of it. You just heard prosecution counsel come up to you, say that the man who burned that house down was the defendant, Jimmy Tanks. But the man who truly did burn that house down, the man who was drowning in debt, the man who needed the insurance money, it wasn't Jimmy Tanks. It was Bertie Darrow. Now, members of the jury, remember, we don't need to prove this story to you, because the burden of proof is on the prosecution. The prosecution, they need to prove their case beyond a reasonable doubt. That means that they need to show you that there is no other reasonable explanation except that the defendant committed that crime. If there's one reasonable doubt that you have, one reasonable question you might ask of the prosecution's case at the end of this trial, you need to find the defendant not guilty. So we as a defense, we don't need to prove anything. We just need to show you reasonable possibilities. Members of the jury, today my client is charged with first-degree arson and attempted first-degree murder. They're not going to be able to prove that beyond that reasonable doubt. Because there's one doubt they can't disprove. Could Bertie Darrow have been the one who started that fire? Why can't that be disproven? Two simple reasons, members of the jury, that I want you to keep in mind as you go through this trial, as you hear witnesses and you hear cross-examinations. The debt, the desperation. First, the debt. You're going to hear from an expert fire and insurance investigator with over 20 years of fire investigation experience. That's Ms. Marina Reynolds. She's going to tell you about that gambling problem. And she's going to tell you about how Bertie Darrell was in crippling debt. She's going to tell you about how he lied about that crippling debt when she investigated. She's going to tell you that that's because of his $900,000 insurance policy. How that could have helped him climb out of his debt, but only if his house burned down. Next, the desperation. Because you're going to hear from a local hardware store employee who watched Bertie Darrell buy the substance that started that fire, paint thinner. What you're going to hear from her was that Bertie Darrell was desperate, that she needed to buy 2 cans of paint thinner, even though Bertie Darrell didn't have enough money, even though Bertie Darrell searched in his car, couldn't find 25 cents. He had to buy those 2 cans. He couldn't wait another day. He had to go in there and argue with an employee for 30 minutes over that second can of paint thinner. Why? Because he was desperate to put his plan into action, members of the jury. As you will hear from Ms. Marina Reynolds, the debt, the desperation. That leads to a reasonable possibility, members of the jury, that Bertie Darrell could have been the one who started that fire. And as a defense, that's all we need. So at the end of this trial, if you found that the debt and the desperation, those are reasonable facts, that they lead to that reasonable possibility, you need to find Bertie Darrell not guilty. Okay, that's an example. Could it have been better? Yeah, in a lot of different ways. It's been 3 months since I've seen this case, and this is also not my statement, but a statement of a student I was kind of teaching. But it's kind of an idea of the structure that you're going after, the effects you're going after. You want to begin by telling a story in ideally a dramatic way that gets the jury to empathize with you. You talk about burden of proof. If you're on a prosecution, you don't need to talk this extensively about burden of proof. In mock trial, the defense has a burden of proof. Sorry, the prosecution has a burden of proof. And prosecution has a burden of proof, which means that the prosecution needs to prove things. So it's usually quite advantageous for the defense. Kind of insist that they don't have to prove anything. They don't need to be reasonable. Just keep in mind that the judge is going to be well versed in this, but the jury, our nary jury, probably won't be as well versed in it. So it's worth mentioning a little bit. You kind of some judges like that you mention counts. I personally don't think it's that important, but some judges like it, so I think it's good to do. And then you kind of go over a structure that you want to talk about. Like, there's 2 facts I want you to pay attention to. There's 2 questions I want you to pay attention to. And then you kind of use that to introduce your witnesses. Because keep in mind that although you kind of are making this story, you're not really coming up to make an argument because there's no evidence for you to argue about. You're just saying what you will hear. And so you want to focus on the witnesses because the witnesses are the meat of the case. And so in this case, we had 2 facts of the debt and the desperation. We used that to introduce our 2 witnesses, Ms. Marina Reynolds and Jordan Parks, and kind of talk about what you're going to hear and how that contributes to the story that we're telling at the beginning. So start with the story, talk about burden, talk about counts, try and come up with 2 facts, and talk about your 2 witnesses through those 2 facts. And they don't have to align super well. When I was kind of editing this in real time up there, I made sure that the 2 witnesses perfectly align with the 2 facts. But in this case, we kind of started talking about the desperation a little bit before. And so we kind of Ms. Marina Reynolds is part of the desperation, the debt and part of desperation, and then Jordan Parks finishes that part of the desperation. But just overall, having 2 facts or 2 questions or kind of some structure for the jury to understand the evidentiary basis of your story is quite important. Okay, going back to the slideshow. And just these kind of are the elements I'm going over. A case overview, that's the story. And I think case overview is a really boring way to say it because you're trying to tell, hopefully, a story that's more empathetic than just a case overview. Um, and you talk about burden of proof. You talk about the charges. You talk about your witnesses, ideally with two facts, and you have a conclusion. Okay. There's one more thing that is pretty important in mock trial, which is really so much of what we've been doing in this opening statement is kind of to make sure that the jury understands. So a theme is part of that. A theme is kind of just one phrase that a jury can use to understand your story. Like earlier, our theme was debt-driven desperation. And you really want to repeat that again and again and again and again. And so there's really only two requirements of a theme. It's memorable and it means something. I gave you very alliterative or rhyming examples here. If it doesn't fit, you must acquit. I don't know if you've heard of O.J. Simpson, but kind of O.J. Simpson was basically at this point a confirmed murderer, but there was a glove at the scene of the crime, and he had a swollen hand. So when they tried to put the glove on him in the courtroom, it didn't fit him. And his lawyer just started saying everywhere, if it doesn't fit, you must quit. And so it's kind of his central theory. It's like the glove didn't fit him. That's a reasonable doubt. So you have to acquit him. But this is very cliche. Please don't use it. Blinded by the need to blame. It's fraud fueled fire. These are very alliterative, but it can also debt-driven desperation is also quite alliterative. But there's also other themes that you can use, like they started and is a theme that I've done before. And it just needs to be memorable and it needs to mean something. I actually used to emphasize this a lot, but increasingly I think it's not as important as just doing the other components well. It's important to have, but the other components are equally, if not more important. Okay, closing arguments. Let me find an example. Hopefully I can find an example, actually. I'm not 100% confident I can. But because my internet is non-cooperative at the moment, my deepest apologies. Okay, so I think the best I can probably find is a closing of a friend slash competitor that I went against. Didn't go against that. This was a scrim against that I was judging. Just kind of to help them out. But it is also formatted in a way that is less clear, but it's all right. So just closing to the end of a trial, right? And so you should be responsive. What are the overall purposes of the closing? What's the evidence you've heard in this trial? Tell us again. Why does that evidence mean you're correct? Right? There's really two simple ideas that you need to go through. And so what is the evidence? What is the evidence changes, right? Maybe you get something really incriminating out on cross-examination. You want to focus on that. Maybe you don't get a piece of evidence in and you need to change your closing statement. So just keep in mind that closing attorney has a kind of the responsibility to be changing their closing statement um, throughout the trial. You kind of start with a framework. You start with what you want to talk about, and then you add to it or you take away from it. So you can see here that he starts when he was writing his closing, kind of before the trial, he had this idea of what is a good thing to start off with, and that's like the classic starting of a narrative, right? You reiterate your story that you told in opening statement, just to remind the jury, but he decided to start with a rebuttal in this case. And closings are really a lot less structured since it's basically just an argument, but there's a couple things you want to do. You talked about facts or questions in the opening. Talk about it again. Um, yeah, that's basically all you have to do. Talk about it again. Um, and kind of talk about how the evidence links to your closing, links to your case, and try and do it in an interesting way. Like he is using some argumentative techniques like rhetorical questions and stuff to try and make it more of an interesting argument throughout this. But I'm not going to give you guys as clear of a structure for closing, just because I think it doesn't have to be that structured as long as you're making a compelling argument. What makes a compelling argument? It needs to be factually compelling, but you also need to deliver in a way that's emotionally compelling to me. Make sure you have good intonation. Make sure that you're not speaking too quickly, and make sure you're always referencing the actual evidence. Like you heard in this cross-examination, you heard in this direct examination, you saw this piece of evidence. Make sure you always refer back to the case. So let me find a very specific part. Right, so it's like, once again, members of the jury, today you've heard from the lead fire investigator, Dr. Harley Blaze. Right, what have you heard in this trial? Why is this person so amazing? Why is their conclusion so amazing? Like they have this super amazing method that we're relying on in this case. What is their conclusion? Why does it help our case? Right. And this kind of isn't a super formalized structure like you have in the opening statement, where it's more formulaic, where you do talk about things in a very specific way, but instead you're just allowed to kind of talk in a closing statement. And it is just talking in a way that is meant to be compelling. And with that, I think that is basically all I will do. Yes, on seam flips actually. You heard earlier about seams that they're kind of things that encapsulate something. It's just nice if you can flip a seam because it's just like kind of like a gotcha moment. Like if the opposing team says it was a fraud field fire, maybe you can walk in on closing statement and say, members of the jury, it wasn't fraud that fueled that fire, but it was fury, right? And you kind of take their case and you're using it to help you. And that kind of responsiveness is really nice. And so it's just super important in closing statements to be responsive because you kind of need to tell the judge that you know you have the capability to be responsive because that's just how mock trial works. You need to show the judge things. Any questions on statements or on objections? That's okay too. If there are no questions, I'll end this here today. Thank you all for coming.